Yeah.
I just added that slide. I'm in good shape. Okay. Solve the world's problems. I don't even know if I can solve your problem. Guide you through it. I am well done. Good.
So,
As long as you keep me busy, I'm in good shape. It's fine, you have to live. That's true. They just keep us busy. And every time they just where do you think that comes from? People you're trying to. So you want to protect people from the big bad as well. Cost. People to pay for it. I showed.
no,
They were signed. Sit back to my office. Yeah. Okay. They have been. They have. Okay. I can check for sure. You will see the email. I'll get it to the right person. Because I know Michael's been doing some kind of stuff. Yeah. I feel like I need to post the return. And so I keep asking Mike. Yeah, I haven't heard yet. So we'll figure it out. It'll get done. I'll let you
Still quick. Mic check real quick. Check. Sibilance. Hey, I just wanted to check it to see if you can hear me okay. Those online.
Also,
There, pop open the chat. All right, perfect.
Let's roll already.
All right, let's get going. Hey, everybody, welcome. I don't know if we need this, but I'm not gonna. No? Okay. Everybody, welcome. For those who are getting food and getting situated, take your time. Feel free to fill in. We've got I think about 50 folks online joining us as well, so that's awesome. And we'll try to manage questions. But thank you so much for being here today and for participating. Welcome to our new offices. We're really excited to show it off. This is a place where we're excited to grow into. We've been at the last space for about 27 years, I believe, and we outgrew that. And so very fortunate and very lucky with the commercial real estate, what it is, that we were able to find our way into this beautiful space. So this is not only a space for us, but also for you. I've offered this to many of our boards. For those of you in close proximity, or if you just need a place to get together as a group that's comfortable and that has the equipment that you need, this whole area of the building is all conference space. And this big area can also be closed off, and it's all for you to host meetings and make it available to you. So hopefully this is one of many events that we'll be hosting. Our goal is to do something like this every month and a half or so, and bring everybody in and have opportunities to talk, and love the opportunity to bring board members together from different communities. There's so much that we can gain from best practices and the experiences that we have, and different whatever projects that we're going through. There's somebody here that's gone through that already, and so being able to share ideas and compare notes is always very, very helpful. A big thank you to Adam for lending his time. He's been just a wonderful resource as we tackle all of this craziness stemming from the latest legislative session. So I know so many of us are just eager to ask questions. For those of you who are online, I'm going to man the chat and make sure that we get to all of your questions. And for those of you, as you have a question, please feel free to raise your hand. I think the goal will be to kind of run through, in brief, kind of each section of the changes that you need to be aware of, and then just have some good conversation around what that means to you and make sure that we answer your questions. So without further ado, I'll go ahead and turn it over to Adam.
Well, thank you very much, Mitch. I appreciate it. My name is Adam Pugh. For those of you who don't know me, I am a partner with the law firm of Cagle Pugh. And I've got a little presentation for you guys today. Let's see if this is working, maybe
I'll
not.
go this way.
Yeah.
Hold on 1 second.
I had a presentation. Okay, here we go. Oh, the little, this thing. All right, cool. Well, that's not me, that's Greg. That's my law partner. He wrote a book. It's called Texas Homeowners Association Law. And this is the legislative update. I like to use this slide. I don't know if you can see it, but it is toilet paper labeled a bill. When all of these legislative changes were being drafted, this is kind of the way we think about it. But now, at this point, they have become the law and we can talk about it. So let me talk a little bit about the use of some of the words that I'll use. I'm not going to belabor the point, but if I say homeowners association or HOA, I mean a residential property owners association. That can be condos, that can be subdivisions. If I say condo association, that's an HOA that administers a condo development. Subdivision HOA is one that administers a subdivision development. Your management company, that's an easy one. That's for you guys, that's a good one. And if I say architectural review authority, that could be your architectural control committee, the architectural review committee, maybe the board of directors. It's whoever has the obligation and the right to review construction or modifications before it happens. And the architectural committee is just whatever that group is. Now, I've divided this up into 3 sections. We've got bills that directly affect all homeowners associations. So if you're a condo, if you're a subdivision, it affects everybody. Then we've got bills that directly affect subdivision associations only, and bills that directly affect condo associations only. And let me say this, this is a pretty large room, but it's a generally small group. And this material, as much as we might be interested in it, it's a little bit dry. So as we go through it, if you've got questions, it'll probably make it more interesting if you just blurt them out and ask them. If you feel like raising your hand to be recognized, I'll probably see you. But if you just shout your question out, I've got these slides to remind me where I was, so I'm not going to lose my train of thought. Now, first, we're going to start with bills directly affecting all HOAs. And so this is a pretty simple one. This is a protection of swimming pool enclosures. And it's about as boring as it sounds right off the bat. It changes it adds 202.022 of the Texas Property Code. And just a little Cliff's Notes cheat sheet kind of piece of information. If you see section 202, you know that applies to all community associations. If you see 82 or 81, you know that that's just for condos. And then, of course, if you see 209, that applies to your subdivision associations. So this one applies to everybody. And it prohibits HOAs from adopting or enforcing a restrictive covenant that would restrict somebody from being able to enclose their pool. We don't see a lot of this stuff in Austin, but in Houston, there was a rule or a law passed that requires these enclosures. The legislature just made it possible to do what the law in Houston required without having to ask your HOA for permission. But basically, a swimming pool enclosure is any fence structure that surrounds a water feature, including a swimming pool or a spa. And as long as somebody is going to create it out of transparent mesh or clear panels set in metal frames, and it isn't included here, you can require somebody only use the color black, not more than 6 feet in height, then they get to do it without having to ask for permission. So pretty straightforward, not a big deal, and likely, more likely than not, swimming pools are in people's backyards. And if they want to enclose them with a fence like this, your ACC probably wasn't going to have a problem with it. Anyway, here's a picture of one. It's a pretty standard looking enclosure, not too offensive. All right, so yes, sir.
So the question that I had is, it looks like the prescriptive thing is you go to this thing and you order a $200 fence, as opposed to if they wanted to put in a wrought iron fence, that would be allowed as well. So does the wording say this is kind of can't prevent this, or that
Yes,
is the
that
prescribed
thing.
answer?
No, you can't prevent the thing that I just showed the picture of. You can still allow wrought iron, and if somebody wants to do a privacy fence and you think that's a great idea, you can always, this doesn't take away your ability to allow anything you want to allow as an architectural control committee. It just takes away your ability to restrict that particular type of enclosure that fits within that definition. Does that make sense?
Well, yeah, it makes sense. The deal you wrote up for us and worded it that way, so that's what I'm a little bit concerned about. We'll talk about.
Well, we can talk about that, but that's the idea. The idea behind the regulations and the resolutions that we put together is to track the legislative language and to clearly indicate to folks that if this is what you're going to do, well, this will be allowed pursuant to the new laws. Anything else needs to be, you still need to get permission from the ACC.
Yeah, well, that was my second question is that pretty much any improvement right now, we require somebody to submit.
And that doesn't change. They still have to submit, but you're telling them how to get it approved. It's like architectural guidelines. You say if you fit within this box, go ahead and submit your application so we know about it. We can track the project, but we're going to go ahead and approve it as long as you fit the bill. Yes, sir.
Do you know if there's any conflict between the state law and municipal laws regarding swimming pool closures?
Well, there wouldn't be a conflict because the new section 202.022, that simply restricts what an HOA can do. So if the city says, for some reason, absolutely no pool enclosures over 4 feet tall, that's not a real regulation. I just made that up. But if the city were to say that, then that would still apply. And if someone came and said, I want to build a 5-foot fence, the city would say, no, you won't be able to get a permit for that. Does that make sense? Okay. All right. So this one is a little bit more significant. And my prediction is this is the one that's going to cause us the most trouble over the next 2 years until the legislature meets again and fixes it for us. But what this does is it modifies 202.018 of the Texas Property Code that already existed. And currently a HOA cannot tell somebody that they can't have a religious symbol 6 inches by 6 inches on their front door. This expands that to be anywhere on the property, and there are now no size limits whatsoever. So an HOA can still enforce restrictions that prohibit the display of a religious item that threatens the public health or safety, violates a law, contains language, graphics, or any display that is patently offensive for reasons other than the religious content. You can still prevent people from installing these things on the common area or common elements, or if they violate applicable building line, right-of-way, setback, or easements, or if they're attached to a traffic control device, street lamp, or fire hydrant, although I can't even imagine how that would go. But what you're going to see is the next time you deny somebody the ability to build a shed, they're going to build it anyway. They're going to stick a cross on it, and it's going to become a chapel. And I'm just telling you that's going to happen. Yes, sir.
Could somebody put a cross in their front yard, say 6 feet tall?
Absolutely, they could. And the example I used was a 30-foot tall cross.
Right.
If you get mad at your neighbor, you just put a cross on the perimeter that just kind of looks over at them in their window. I mean, there's no limitations to this. I'm not sure it was all that well thought out, but in Texas, with respect to HOAs, you are about the most protected from for your religious liberties in any state in the country. Now, for those that are online, I know that you're all muted, so
Yeah.
Why don't you want to use the chat function?
Yep, either the chat function, or there's also the ability to click the raise hand button, and that'll let us know that you have a question, and we will unmute you.
So either of those are good ways to ask questions.
And Trish, did you have a question?
Yeah, so with regard to religious displays, is there a way to distinguish between holiday decorations and religious displays? Like, a Christmas tree sign that says Jesus is the reason for the season?
I'm not sure, and we've thought about that because obviously, let me back up one step. There's one provision in this new law that limits these displays, and the legislature tells us that these displays need to be motivated by a sincerely held religious belief, whatever that means. So now you're the sincerely held belief police, and you're supposed to figure out if people mean it or not. With respect to your question, a lot of people put up Christmas lights, and probably that's more of out of the spirit of the season versus any kind of religious reason. But if you told them, hey, it's July, it's time to take down those Christmas lights, it's right there in the name. And they responded, no, we celebrate Christmas all year long. And that's my sincerely held religious belief. I'm not sure if you'd be able to force them to take it down. This hasn't been tested yet. It goes into effect. Well, actually, it's already in effect. And we haven't had it tested yet. So as soon as people start learning about this new law, I imagine we'll get some tests.
So Adam, inevitably, a ACC committee, right, is going to have one of these applications in front of them, and they're going to have to make a very difficult decision. Any suggestions on how to approach that, right? Is there, I guess my question would be at some point, it's probably a good idea if you think that it's going to end up on the front page of the newspaper or a news story, get legal advice.
I would say so. I mean, my advice to boards of directors and architectural control committees every day, all day long is just be reasonable. Just be reasonable and think about, put yourself in the place of the person making the request. Put yourself in the place of the person that lives next door. And what would you want the association to do? And that's just what we're going to have to end up doing is thinking about, are these the battles we want to have, or do we maybe want to let this go? One of the things you can do, and one of the things we thought about including in our standard resolutions, but shied away from, was when somebody applies for one of these religious display type exemptions, to ask them, in 500 words or less, please explain to me the sincerely held belief that motivates your desire to build a 35-foot cross or whatever it turns out to be. And then you can use that to decide whether or not that this is something that is trying to skirt a guideline, or if they really, want to build a chapel in their front yard. Yes, sir. Well, the ones that come to mind.
Repeat that question.
Yeah, are there preemptive constraints that the boards can put on these types of displays? The only ones that are available are, it must be motivated by a sincerely held religious belief, and it can't violate building lines, right-of-ways, setbacks, or easements.
Size, color, flashing lights, location, none of those.
If you could argue that it somehow, caused confusion with traffic lights or blocked the view around the corner, if it threatens the public health or safety, but that's a pretty high burden for a display. I mean, it'd be hard to argue that Christmas lights do that. We're pretty wide open here.
So Adam, in the language that we just went through with you guys when we did our guidelines, we had put in there, or I wasn't a part, but our ACC group put in there a limitation. It is of size no larger than 3 feet or by 2 feet, right? Just because they had worded it. I think there was a previous session where they had recommended doing some of that to try to preempt it. There's nothing in there that says it. Does it say of any size? Let me ask that question.
Size isn't.
Not mentioned.
No, and in fact, we've redlined that. We took that out of there. You can't. We can't have size limitations.
Okay.
Now you can take a shot at putting them in there.
Would you recommend though that we take it out at this point?
Yes.
Okay.
Yeah, I wouldn't try to start in violation of the law when we're trying to, to be in conformance with it. Yes, ma'am.
So if we already have people that have like a small statue or something, is that like grandfathered in? Is that, if it's already been?
Well,
Or is?
no.
Okay.
No, but I mean, if they already have it and it's okay, then it's especially extra okay now. I mean, it's gotten easier to have that stuff, not harder. So if they already have a display and you haven't done anything about it, well, you've got 2 days, but they're about to be able to have it forever.
Yeah, well, it's a small statute.
Sure.
Adam,
Yes, sir.
in dealing, we'll use the analogy, for example, of the holiday lights. We have parameters that restrict the number of looms that will affect the neighbor's house. Based upon this law, does that overshadow then the bylaws of what we have?
Maybe, maybe not. Here's the argument I would make, just, shooting from the hip right now, is that you can have, if you have a sincerely held religious belief that requires you to have Christmas lights, what about your sincerely held religious belief is violated by turning the lumens down? You know what I mean? And so I think that you can impose restrictions that don't prevent the display.
But at the parameters of those restrictions.
But that's not in the law. I'm just making this up as we go, because there's all kinds of holes in this. There's all kinds of things that the legislature didn't consider, just like what you just said.
We have another thing too, where any lights that go up can't be on at 10 o'clock at night. So get into, I guess, the gray area, how to respond to it.
So you can decide to have that dispute with somebody or not. It's going to cost time and money to have it. And I think, writing a letter to somebody and saying, you need to turn your lights off by 10, or those are really, really bright and they bother your neighbors. Would you consider maybe some lower wattage, maybe not be the Griswolds this year? But, if we're just going by what the legislature said, you might lose that if we go to court and fight it.
And as expected, there's nothing that defines a religion, of course.
Oh, no, there's nothing that defines a religion, nothing that defines sincerely held, nothing that defines belief. And so we're just kind of left to our own devices there.
We got a couple questions online.
Sure.
Michael?
Hey, yeah, so the slide here shows that the HOA can enforce various restrictions that you list here. My question is specifically, do those restrictions exist in the law as stated? Do we need to update our architectural review guidelines to name these explicitly? Is it generally understood? Or can the review committee essentially determine these violations of these restrictions at review time? Just trying to make sure we get ahead of any due diligence that is needed.
Well, there's probably nothing you need to do. I mean, especially with your guidelines. Guidelines are supposed to already be not more restrictive than the declaration. And you can't use guidelines to expand restrictive covenants. So whatever exists already in your declaration, you can enforce that, and you don't need to update your architectural guidelines to put people on notice that you're going to enforce those. You've already got building lines, right of way, setbacks, and easements built into your declaration, and of course the plat. And everybody's on constructive notice, which just means that it applies to you whether you know about it or have read it. It's filed in the deed records and applies to your property. So no, there's nothing else to do. We have these limitations on how we can enforce restrictive covenants.
Adam, will we get this being emailed to us? The amount of information that you're providing, it's next to impossible to keep track of.
Yes, sir. Yes, sir. And in fact, I've got a 2-page kind of Cliff Notes version of all this. We've prepared resolutions to bring you up to speed that are going to contain all this information. So we can get you this information. That's today's about answering all these questions, and we can deliver the information in a digestible form shortly. Yes, sir.
Our state that holiday decorations can be up 2 weeks before and 2 weeks after or something like that. So, we still follow that, let somebody come back to ACC and then say, I want to keep my house all year long because I have these beliefs.
So the question is, our declaration has a time limitation on Christmas decorations. Can we still enforce that? And then he asked a little bit more of a nuance of how to enforce it. So what you're talking about now is really strategy is well, we still don't really want people having their Christmas lights up in July. What do we do about that? And I think your approach is probably a very practical one, which is kind of ignore them. Kind of ignore that they can keep them up all year long if they claim it's a sincerely held religious belief that we need to have Christmas lights in July. Now, we're making a lot of Christmas lights because it has the word Christmas in it, but they cease to be Christmas lights in July. And so I would be really surprised to hear somebody's sincerely held religious belief about having those lights up in July and what the purpose of that is. I say that, we're going to hear about it. It's going to happen. But I would do exactly what you said, which is continue to enforce it. You know, you aren't tyrants. You're not sending out $1,000 fines for Christmas lights. Continue to send the courtesy notices. Hey, we don't want Christmas lights up, you know, on February 1st. It's time to go ahead and take those down. Just a little quick reminder. And you're going to get most people either complying or calling and yelling at you and then complying. But ultimately, most people are not going to go file a lawsuit over their Christmas lights. It's probably easier just to go take them down. But I mean, that's a good point and certainly one to consider, as long as you understand the risk is if you proceed down that path and you issue fines or you take some kind of enforcement action, they could sue you and win under this new law. Potentially, there's a risk. Yes, sir.
I mean, this applies to all religions. I mean, like in our neighborhood, the Festival of Colors is really big. I mean, we'd have to follow the same open-mindedness, like we've been talking about Christmas lights, the festivals like that.
We're about to learn about religions we never knew existed.
Yeah, I think we're going to make them up too. This doesn't mean that it has to be a sincerely held religious belief of a religion you've heard of. I mean, somebody could make up their own religion and decide that whatever it is they've put up is a symbol of that new religion. Exactly. So we'll see what happens.
Let's take a quick question online.
Sure.
Daniel?
How many of these points are we going to be discussing this evening?
There's
10 or 12?
Yeah.
Well, if we spend 40 minutes on each one, we're going to be here all night.
Yeah,
good point. Let's move on.
Yeah, let me get one more question.
This is the most interesting one now.
Yeah, this is a meaty one. Let's see, Michael.
Hey, yeah. So yeah, just a follow-up from the earlier question. It states on here that HOAs can no longer remove non-conforming items, but we also say that we can restrict common property and common area. Is the HOA within its right to remove a religious item if it's sitting on common property?
That's an easy one, yes, and without notice or anything else. If somebody decides to install something in the common area or on common elements and they weren't supposed to do it, you just go and you take it off. You don't even have to tell them about it.
Perfect. Thank you so much.
Yes, sir.
All right.
All right. And so, this is an example of a very well put together religious item display. But you will be so lucky if that's what it looks like. All right. So the next one, which is I would call probably the second most interesting topic that we'll hit today, adds section 202.023, the Texas Property Code, and it prohibits subdivision associations. So now we're just talking about subdivision associations. I'm sorry. It's all associations, but it's only going to really apply to subdivisions. It's going to be very difficult for a condo owner to put a perimeter fence, for example, around their unit. But it prevents subdivision associations and condos from installing security measures, which include, but aren't limited to, security cameras, motion detectors, perimeter fences. Now you can still adopt and enforce rules that prohibit security cameras on common areas, and in condos, that's pretty much any exterior surface. And you can also regulate the type of fencing that can be installed. Now, what is interesting about this is it uses the term including but not limited to. So it doesn't define what a security measure is, but just uses that term in its regular, common English meaning. So that could be almost anything. We joke about that would include a moat, but it would include all kinds of other things like, a watchtower. It could include burglar bars. That's the one that I think would be kind of the most offensive. You drive into a perfectly nice neighborhood and the first 5 houses all have burglar bars. I can't think of a better way to decrease property values in a heartbeat. So it's pretty simple. You can't do anything about those specific items other than, the front yard fences. And you can require those to be of a particular type of material. And certainly they're going to have to be in accordance with local codes. I represent close to 1,000 HOAs. I'm not familiar with any association that is not within some type of municipality or county that allows anything over a 6-foot fence. So at least we can rest assured that these fences shouldn't be over 6 feet tall. And we can certainly limit the types of materials used. Most of the associations that I work with are opting for something like wrought iron or its aluminum decorative equivalent in the front yard, and then whatever you normally allow, past the front building line. Yes, ma'am.
Okay, I'm confused between when you say perimeter fence and a front yard fence. Can you define the difference in those?
Sure. So the question was, what's the difference between a perimeter fence and a front yard fence? So the perimeter is just the exterior boundary of the lot. So what the law says is you can't prevent somebody from having a perimeter fence, but you already don't in most instances with respect to the backyard. The reason that this is going to become a problem is when people start putting wooden privacy fences in their front yard on these small lots, it's going to look kind of crazy. And so I'm just distinguishing between perimeter and front yard to mean a perimeter fence that's in the front yard that you can see. And that's what's going to cause the problem. I mean, most of the time, you've got guidelines for the backyard fences, and you tell people, well, you can't build a fence past your front building line. In a lot of communities, in some you can, but in the ones you can't, it's for a reason. And so now we've got to put a resolution out there that tells people, okay, now you're permitted to have these types of fences, but we're not going to approve them unless they're made out of whatever we decide they're going to be made out of.
Because in your resolution, you state that it's a perimeter fencing, you don't differentiate whether it's a front yard fence.
Right. So certainly if somebody wants to build a perimeter fence out of wrought iron, and we decide that that's okay, then we would probably want to see wrought iron go all the way around.
Although backyards, privacy, it might be 2 different types of materials.
It might be, but if somebody wanted a wrought iron fence in their backyard and they had one in their front yard, it probably makes sense to say, okay, that's fine. But you don't have to. So what we're saying is in the backyard, it's whatever we were telling you it should be before.
Got it.
And now in the front yard, it can only be this particular type of material. Does that make sense?
It does. Go ahead.
I think what she's saying is because in the resolution, it's just mentioning perimeter fence. So how do we, in the resolution, how do we differentiate between the backyard and front?
Oh, well, that's why there's blanks in there. And so that's the language that we put in will determine what that is. So we've left the architectural committee or the board, whoever's making these decisions, the leeway to decide it can be whatever you want. If you want to put, 4-foot tall white picket fence is the only thing we allow in the front yard, you can do that. But we can talk about that later. I think you might be hung up on certain language that the entire resolution should be self-explanatory. Yes, sir.
Let me understand. If my neighbor under this new law installs high-intensity security lights and security cameras around it, I, as the neighbor, being infringed upon by these lights and cameras in my bedroom, do I have any resolution homeowners association.
Well, the question was, if my neighbor installs high-intensity security lights and other security devices that basically become a nuisance, whether it's from a glare or some other type of intrusion, what recourse do I have with the HOA? Now, the answer to that specific question is nothing. Since the HOA can't do anything about it because of this new law, you can't make the HOA do anything about it. You individually probably have a claim for a nuisance. If they've got these lights and they're directed into your window, you still have a claim for nuisance. This law has nothing to do with common law nuisance and property rights and your ability to quietly enjoy your own property. So you still have recourse. It's just outside the purview of the HOA.
So it's a civil matter.
Yes, ma'am. It's a civil matter.
So previously, in the last session y'all did, we got the advice that, and we put it into ours, where we can say that those cameras have to be attached to the main dwelling. Like the way we word it is attached to the main dwelling or garage, has to be viewing, recording the owner's property and not primarily viewing, recording a neighbor's property. Are you saying that we're not allowed to have that in there? Because that was the advice we had received previously.
Well, those sound so reasonable. It's hard for me to stand up here and say, well, don't do that. I mean, if you put that in there,
right,
I'd be shocked if somebody questions it, because those are very reasonable restrictions. And why does somebody need to record a neighbor's property that they ought to be recording only their own? So if somebody is motivated by a sincerely held security desire, then they're going to follow your guidelines. If they challenge that and say, I can put up security cameras that look at whatever I want, see section 202.023 of the Texas Property Code, I don't know, maybe they win. It's never been tested.
Madam, along those lines, okay, to what degree can an HOA actually look to a city for some relief over this, city codes and so forth? And you mentioned a civil issue with security cameras. What degree can?
Yeah, the question is, what can an HOA do with respect to getting a city involved with code violations? Almost every city operates on what they themselves call a tattletale program. And so, in Austin, 5 or 10 years ago, we only had like 2 people that drove around to do code compliance. So they waited on calls from property owners to report violations. So you're certainly within your rights to call the city code compliance department and report these types of violations. There's nothing wrong with that. And maybe they'll do something and maybe they won't, and maybe they'll get around to it. But HOAs won't have the right to do anything about those issues.
Question on the phone?
Caller, are you there?
Is that Vicky?
Oh, hi.
Hey, Vicky.
Let me turn off the video. So you seem to be focused on wrought iron on the front, and I did just want to bring up that I think there's nothing wrong with black chain link fence, which looks, as far as I'm concerned, just as nice as wrought iron and is a little less expensive, the black powder coated stuff, and it will also keep your pets in, which wrought iron will typically not do. So I just wanted to throw that out. So I'm not thinking that everyone thinks that wrought iron is like the only option.
No, I think there's a lot of different ways you can go. It's really just the aesthetic appeal of what you're going after. I think the opinion of many, and that actually would encourage some discussion here to get some thoughts. I've seen a lot of associations go the route of some kind of wrought iron masonry mix where the masonry matches the facade of the home. That's decorative in nature. It's also very expensive. So the likelihood that people are going to go installing a bunch of perimeter fences all kind of, help reduce that. So, so that's a piece of that. I think there's a lot there that's up for discussion, and curious as to what you guys are doing in terms of the types of materials that you're picking for that type of design.
The other thing we did is did contiguous across even the driveway, and it has to be contiguous completely around, otherwise it's not a security fence.
Mm-hmm.
And so we limited it that way, and that, it's of course increases the cost, but nobody's going to want to have a gate across their driveway, most likely, or they might, but those types of things. If there's a gap, it's not a security fence.
There's also setback requirements that, can you go off the, or is property?
Not really.
Yeah,
How could you don't do setback requirements when you put in privacy fence all the way around
Right.
your yard for
Right.
the
And
rest
there's
of
no-
it?
Yeah, there's no mention of setbacks and you know, building lines in this provision. And in the very same bill, there's mentions of setbacks. So I would suggest the legislature, when they said perimeter, they meant, you know, all the way around the actual property line. And I think that's a great point about, you know, requiring it to be, you know, to close. And because otherwise, how is it a security fence if you can just walk around the side? It's a
We
good
said
point.
we've got to connect to the backyard fence and be continuous all the way around. And we also restricted for safety, things like electric.
Yeah.
For
those are-
general public things, we restrict.
Those are great points. And Vicky, you know, I think you've got a great point, and that's why every single association will, and architectural control committee has the right and the duty to figure out what works for your neighborhood. And if black chain link fences are what your neighborhood wants to do, then you certainly can go for it. I was simply suggesting that in my experience talking with boards over the last several weeks, I haven't heard anybody mention black chain link fences, and it's been all wrought iron. But I appreciate you bringing that up because I understand we've got a diverse group of folks.
Yeah. Trish, did you have a question?
Yeah, so can we restrict side fences that would prohibit a neighbor getting to their air conditioning unit or meters, or because our side yards meet with our neighbors. And so if they wanted to put a fence from the backyard all the way around the front, the neighbor wouldn't be able to get to their stuff.
Well, that's super interesting. Wow. So if the perimeter of your house encloses some of my stuff, that is a interesting problem to have. I suppose the solution could be a gate that locks and the neighbors share a key. You know, we're gonna have to be creative in that situation. It's hard for me to even kind of imagine what you're describing. But I guess I can, and I think there's probably a solution, but I think you can rest assured that the HOA could certainly prevent somebody from installing a fence that prevents you from getting to where you need to go on your own property. I think that's a great point and certainly something that could be prohibited.
Thank you.
Adam, I need some clarification. To my understanding, effective September 1st, no board member could be serving on an architectural control.
Correct.
Is that accurate?
Yes, sir. That's coming up.
So if no member from the HOA or COA or whatever the association is, where does the HOA have any power, influence, authority to invoke anything if the committee is made up of people outside of the board members and from the community that may have a different interest, desire, and result?
Well, I mean, the board is still going to have the right to appoint the ACC members. And so it's the board's duty to appoint people that share the values that the community holds as important with respect to, you know, the architectural design. So, you know, that's just more of your duty as a board member to choose wisely those ACC members.
Again, the apathy that exists, I'm not looking to be contrary, I'm looking for.
Sure.
The apathy that exists, you have a community of 1,100 homes, and the quorum is basically 10% because of apathy. Why wouldn't that carry over to a community that can't get people on architectural?
Well, it's a huge challenge. And I think that's one of the things the legislature wasn't thinking about is that there is apathy. And you know, we care about these issues. But you guys represent thousands and thousands and thousands of members of your community. And there's 40 of you here. You know what I mean?
Yeah.
You're right, it's apathy. And so you're gonna have to deal with that. And that's one of those problems I don't have a solution for.
But let me go.
I might.
back to that.
Well, yeah.
Okay.
Is this the next slide, by the way?
It could be.
Okay.
Where does the management
Yeah.
come in to provide some type
Yeah.
of help with that being possible?
It's a great question. So obviously, we've got to work through that. And one of the things that I actually wanted to pose to you, and something that we've been considering for a while, since the pandemic hit, we've seen an exponential increase in the number of architectural requests that have come through. Traditionally, that's something that we as a company have never charged for. Many management companies do. They'll, handle the receipt, but they won't review it for completeness, or if they do, they're not rubber stamping approval, right? So they're just kicking it to a committee. But we've got a growing need of communities that are trying to find a solution, because there is nobody that's going to step up. And even if they do in the next couple of weeks, those positions always turn, because people, frankly, in a community like yours, if you're getting, 20% of the community annually submitting an application, they don't want to go through that work, right? And so one of the things that we are looking at, and I wanted to tee up as a question to you all, obviously in kind of hiring the right person, if we're going to actually approve something, review it, approve it, have an intimate knowledge of what it is that your community's, restrictions look like, and managing that, it takes a pretty good level of acumen, pretty good level of detail. And being able to do it at scale is something that I'm trying to get my head around. How do you do it and do it well? And so we are exploring maybe starting a group, and really kind of an in-house team that would take the place of the committee, work very closely with the board to make sure that there's, some, clarity around, wherever we have to come back and ask a question to the board, but ultimately formally approving. It gives me a lot of heartache to be in a situation where we're approving something, because human error always plays into the equation. Boy, is it easy to point a finger at the guy that, approves the wrong color house, and now it becomes the talk of the neighborhood. And so it is something that we're exploring, and something that we've got to figure out a solution for. We are in the process of doing that, figuring out how to price it, how to make it work, and how to make it economical. But it is something that we are working on. And I guess one of the things that I want to tee up is there enough of an appetite for that? Before going out and hiring, a body or 2 or 5 to handle that function, is that something that you think would be valuable to you? Is it something that, yeah.
We'll interact.
Yeah.
Just brought up for our.
Yeah.
Is it possible?
Yeah.
That the neighboring HOA can't have people from their board on the ACC, that the neighboring HOA that has an ACC that's active carry over to their neighboring community?
Kind of a board swap.
Yeah.
I don't know. That's a pretty good idea. There's nothing that would legally prevent that. Say, hey, we need an ACC, you need an ACC, we'll be yours, you be ours. It's a pretty good solution, really.
He hasn't seen my consultant fee yet.
We'll have to talk about it.
But it is something, it is something that we've been weighing, just because of the astronomical number of applications that are just flooding through. So, but taking it to the, next step of really being, having someone to the level of an architect, or somebody who knows what they're doing, especially on some of the larger projects, right? When you're adding an addition to a home, or you're adding, installing a pool, and you've got to get in and actually, do visual inspections of this stuff, it's figuring that out. I think one of the things that we could do, to offset that cost, and it's something that we're actually about to introduce into Town Square, is a way that the association can set a fee for that. And let's call it $25 for the standard application, maybe $150 if it's an addition to a home that takes, a lot more correspondence, a lot more looking at plans, understanding what's going on in more detail, and just passing that through the homeowner submit. There'll be a vehicle in that system that will allow us to accept the payment. And then that is either, paid to the HOA. We'll figure that out. But there's something to that. And there's something that, like Gabe and I've had conversations. He uses a service similar to that, where it's a third-party reviewer, and it's, but what's the value of it? How do you do it? And how much is the association willing to pay for something like that? So something that we're eager to do, because there's just such a growing need. You imagine the restrictions start at home of communities 40 or more. So there's a lot of communities that are 50, 75, 100 homes where they have no participation, right? Like you can barely get anybody to join the board. I wonder why, right? So just trying to figure that out has been tough, but it is something that we're working towards. And we're actually working right now on trying to, get somebody in here to do that. Start off with a pilot of, 10, 20 communities and then see where we go from there and see how we grow it.
So I have a question and a comment on that, but I
Yeah.
also want to make sure that we get through this.
Yeah.
Is there anything else on this? And then I want to go back to the other.
Yeah.
There's nothing more on the set of security measures. But I do like the match.com for ACC members. That's pretty good.
Yes, that is
That's
good.
pretty good.
All right.
haven't heard what else somebody has to wait.
I can't wait. I can't wait. So those are my security measure examples. So
We'll come back to that.
Yeah, we'll come back to that. This is a simple one. This modifies 202.006. It applies to all HOAs, kind of. It prohibits the collection of assessments if your dedicatory instruments authorizing the collection of regular assessments are not recorded in the public records. Well, they all already are. So I wouldn't worry too much about that. We can go to the next one, but I wanted to be complete with our analysis there.
Does that include, for example, variances that get filed for the county?
Variances on.
Well, so just to be real clear, this requires that the dedicatory instrument that states what the regular assessments are is filed in the deed records. I can't think of an instance in the last 16 years of doing this where that wasn't already the case.
Right.
So I'm not sure what problem they were solving here, but it's fixed now.
Sounded good.
Yeah. All right.
Well, but I thought the issue there was that every single one of the documents have to be filed.
All of your dedicatory instruments already do have to be filed in order to enforce them against an
So my
owner.
question is a variance, one of those documents?
It's not.
Okay.
And I still recommend you file it in the deed records for a bunch of different reasons. Mostly so that there's institutional memory, so that when you grant somebody a variance to have a shed in 20 years, somebody didn't go, well, how do they get a shed? Well, it's right there in the deed records, but it's a good question. This section, this is the COVID-19 immunity from liability. It doesn't apply just to HOAs, it applies to everybody. But rest assured that as long as you didn't knowingly fail to warn people about a condition or knowingly failed to implement or comply with government promulgated standards, you're not going to be on the hook for anybody getting sick from COVID-19. It's a pretty easy standard to meet. Signs like, we don't sanitize anything, or, we are not actually, doing anything different. Swim at your own risk. All the kinds of things that everybody did during the pandemic are going to be enough to satisfy this provision. The other thing is, a couple of years ago when COVID-19 was a brand new term, there was a lot of concern that there were going to be all these lawsuits because people got sick, and we're going to blame the HOA that didn't shut the pool, or we're going to blame the HOA that didn't sanitize every surface in the common area. None of that really happened. And so this change in the law is a reaction to a problem that we anticipated, but that never came to pass. So just know that as long as you were being reasonable about your COVID-19 precautions, that you're not going to be on the hook from lawsuits.
Side note, Adam, obviously getting into variants and, COVID continues to pop up as, a topic of conversation, no matter how hard we try to shake it. But for board members in attendance, is there anything right now? Obviously a lot of associations relaxed a lot of the precautions that they were taking. Some were hiring staff to, disinfect and, do all these things. And now, and we had capacity control, and we had folks doing reservation systems and all kinds of stuff. And we relaxed that this pool season. With the kind of rise in COVID cases, is there anything that you suggest that an association do to take precaution at this point? Is there?
Not really. I mean, at this point, if you haven't heard, about what you're supposed to do to avoid getting sick, you've been under a rock. I think everybody knows exactly how to stay safe and stay healthy. There are, if you have mandates for certain things like wearing masks inside or not being in certain groups of people, but you have to abide by those rules, but you're already doing that. And so the best thing you can do, and in accordance with this provision, is just put people on notice. If you were doing certain precautions and you have now stopped, well, you probably need to tell people that. So if you were going through and wiping down all the surfaces in the common areas, every 30 minutes with bleach, and you've just decided now, hey, it's too much, we're not going to do that anymore. Well, go ahead and let people know you're not going to do that anymore. Put up signs at the pool, swim at your own risk. We are not taking any particular precautions. Wear a mask if you want to. As long as everybody is informed of what you are and aren't doing, you're going to be in good shape.
We had a question online. Mike?
Yeah. Can you hear me there?
Yeah, we sure can, Mike.
Yeah. Okay, great. Okay, so I can see this meeting's going to drag on, but I want to.
Sorry, Mike.
It's okay. I'm new. I've been on the board for a 300 plus community for less than a year, and so I'm still learning.
Yeah.
Absolutely. But the problem I see in our community, at any rate, is this attempt to impose the will or judgment of a few people on the community as a whole. And I have no problem with that when it involves things like the upkeep of the house or, cars sitting on blocks in the driveway and all that sort of stuff. But when we get into these things like the religious display stuff and all that other stuff, where a small group of people seem to be setting standards that go along with what they think. In other words, if it's not specifically outlined in the CCRs or some other document, why are we messing with it?
That's a great point. And I think your question kind of speaks to, what is the role and the duty of a board member? And the reason that board members from the community exist is because, well, it's a number of reasons, but standards change, building materials change, the community opinion about certain things change, and the board members being elected every so often from the community are supposed to be the voice of that community. And so your duty is to try to, when you make these subjective decisions, like, when the declaration says that a lawn shall be kept in a healthy and attractive manner. Well, what does that mean? Well, it's your job to decide that. And that's kind of what you signed up for, is to make these tough decisions. I tell my clients all the time, being a volunteer unpaid board member on a nonprofit homeowners association, if you've never done it before, it's the most thankless job that exists on the planet. You will have long hours. You come home from work, you've got more work to do. When you signed up to do this, you probably had in your mind, look, I just want to do a good job for the community. Maybe somebody in the past wasn't quite doing a good job. Maybe they weren't putting as much time as you thought they'd put into it. And you find out pretty quick, it's a lot more work than you ever thought it was going to be. And nobody cares and nobody says thank you. And that's just the bottom line. It's how it works. But you still have a duty, a fiduciary duty to the community to try your best and to be reasonable. And some of these calls are tough, but that's what you signed up for. And being the arbiter of what looks good and what looks bad, it sounds a little bit daunting. And who wants that responsibility? Well, you do. You signed up for it. And so that's just kind of the way it is. And those are the tough decisions you're going to have to make. All right, so let's move on to my next section here. This is bills affecting only subdivision associations. So previously we were talking about the new changes in the law that affect all associations. Now we're just talking about subdivision associations. This particular section requires all subdivisions with 60 or more lots that are managed by a management company. So it's everybody in this room to have an internet website. Good news is you've all got one. It also requires all subdivision associations with 60 or more lots to publish the current version of all dedicatory instruments to your internet website. That is just a little bit of a modification on the prior obligation, and it's pretty straightforward. So are there any questions about that?
Internet website, that means town square?
Yeah,
Just
yeah.
town square?
Yep, Town Square, and every community also has a website that's available. If you go to our webpage, type in the name of the community, there's a public facing website. And if anybody's interested in a custom domain for their association, we can xyzhoa.com. We can buy the domain. It's like $50 for 3 years typically. And we can attach it to your website. And then that way you don't have to go to our website to find it, and you can just point people there. And it's all customizable through Town Square. So it adds another layer of just communication, but everything, the website and Town Square kind of connect. So whatever documents you want to upload and publish to the public facing website, you can through Town Square, click a button and it'll show up on the website, which is cool. Yeah.
All right. Okay, another big one are resale certificates. The legislature capped what you can charge for resale certificates at $375. Updates are only $75. There's no provision for increasing these amounts over time. And it modifies the number of days to produce a resale certificate to 5 days instead of 7. And it increases the amount of damages that can be awarded. Previously, if you violated the obligation to get the resale certificate out in time, you could be fined up to $500. Now it's $5,000. But rest assured, your management company's on top of that. And I'm pretty sure they're meeting those deadlines on a daily basis.
We don't want to get fined.
We don't want to get fined. So not too much interesting there. Let's see, management certificates. This is a big one. We are currently in the process of assisting your management company with updating, hundreds and hundreds of these. And one of the things we're doing is we are obtaining a title search, because one of the new requirements is that you include all of the recording data for the declaration and all amendments, and you're supposed to have all of the dedicatory instruments posted on your website. In my experience, about 5 or 10% of associations don't even know what all of their dedicatory instruments are. And so it takes a title search to find those, and we're getting those done for you. Besides that, your management certificate has to identify all of the charges that could be charged to an owner when they're selling their property. You've also got to identify the website address for the website that you're now required to have. And of course, it's got to be recorded in the official public records of the county, and now recorded with the Texas Real Estate Commission, which is a brand new requirement. But again, not much that's too interesting about that. I think, did Vicky have another question?
Yeah, Vicky, you had asked to explain one of the bullet points. You can feel free to unmute if you want to ask.
Okay, it was the bullet point on the one before where you talked about curing a whatever, the 5-7 day thing.
Yes.
What does, I mean, you sort of went by that so fast. So is it the number of, you said something about the number of days between when you give it. To me, to cure a violation means you've noticed something that these people did, like they have an air conditioning unit in a window and they're not allowed to do it. So how long do you wait to force them to fix it?
No, this isn't talking about restrictive covenant violations. It's talking about a violation of the obligation to provide a resale certificate. It just never comes up. That's why I flew past it so fast.
Okay, well, it seems like if people have violations, you don't want to give them a resale certificate until they fix it, right?
Not a violation of the restrictive covenants. This law, you can violate this law, which requires you to provide a resale certificate in a certain amount of time. That certain amount of time went from 7 to 5 days.
Okay, all right.
Yeah.
Thanks, Vicky.
All right. Regular old days. All right. So it also has to be filed with the Texas Real Estate Commission now. And there's a new remedy for failing to file the management certificate. The owner is not liable for attorney's fees or interest associated with unpaid assessments during the period of time that the management certificate is not on file. That's a new thing, but the amendment for filing it with TREC goes into effect December 1st, so we've got a little time there, but we do have to get the management certificates updated in the next 3 days. So we're working on that. All right, so one new section in 209 is 209.00505. It applies only to subdivision associations with 40 or more lots. It does not apply during the development period, and it restricts board members or their spouses or household members from serving on the ACC. And it creates a new procedure for appeals of denials by the architectural committee to the board. So this is kind of a big deal. I'm sure in a lot of your associations, you're on the board, you're on the ACC, and if you wanted to try to find volunteers to replace you on the ACC, it's going to be nothing but crickets. And this is a big problem, and it's the one we discussed earlier. There's going to be all kinds of solutions, I would imagine, coming out, professional consultants that will charge you to do this, that will increase the cost. And you may not have the right in your declaration to charge a fee to review applications. So I see in our future a lot of amendments to declarations that allow for charging a nominal fee so that we can get some professionals in there to comply with this new law.
I got a lot of questions about this one. So, because I get them all the time. All right. So let's say that manager's working very closely with a board member who has always been the one that's been the default approver of ACC applications because they're the only ones that are willing to do it. And they've got a lot of intimate knowledge about the community. How involved can a board member be in reviewing it and saying, hey, I think this looks good, approve it?
I mean, as involved as they want. You can get a new ACC that has no idea what they're doing and relies 100% on the opinion and the advice that they get from the guy that was doing it for the last 15 years. They just have to be the ones that ultimately, vote to approve or decline the application, and they can do that upon the advice of anybody that they choose.
And that could be the manager.
It could be the manager. It could be the old board members. It could be the current board members. This doesn't prevent you from talking to the board. It just prevents you from being the same people. So it's really.
So shameless plug, right?
Yeah.
So we've got this tool in Town Square, that architectural review thing. So essentially what you could do, we could set up a system where the application comes through. And for those of you who don't know, there's like a new module in Town Square. And if you don't have it turned on and you want to turn it on, we'll turn it on for you. But it allows us to set up forms, custom forms, and you can set up as many forms as you want electronically. So a homeowner, when they have an application to go in, and they just fill out the form, attach the supporting documents, whatever it is that you need in order to review it. Board can take a look at it in the comments, and every board member has admin rights into Town Square. You can look at the application and say, hey, John, right, manager, this looks good to me, go ahead and approve it. And so we go ahead and approve it, and we can send the verdict letter through the system to the homeowner. So for those of you who are kind of in a pinch and you're staring down this September 1st deadline, the idea is that while we're the formal approvers, we can get input and we can kind of continue to keep that ball rolling. Ideally, best practice wise, we recruit some volunteers, right? And it's going to take a little time. It's going to take a campaign. We need to send out a mailer or, have an event and try to sucker people into joining this and get them going. I think that's the best deal, right? You want to create a little separation because the whole idea here, correct me if I'm wrong, is that the board have this appeal authority, right? The appellate court to a denial of an application, and gives you the ability to be more objective as opposed to if you were the one that denied it, now you're the appellate court and you're denying it again, right? And so trying to create a little separation is probably a good thing, and certainly takes more off of your plate as a board. We're working on a solution to try to help you there. But some of you are going to be in a situation where your documents don't allow you to charge for something. And so we've got to get creative. And so that might be a solution, something that we can explore, and we'll see where we go from there. I think I know a lot of people were panicking. I've seen a lot of board members who have jumped off their board because they were the only ones doing it. And so they had somebody else fill in for them on the board and they just focus solely on the ACC piece. Love to keep you guys on the board, right? And so if there's a way to work through this and help you out with that, we'll work together and find a way.
So this goes back to what I was gonna, so this is a good time for it. Our DCCNRs, the ACC is the one who sets the or enforces or comes up with the guidelines and all of those rules. They also are the ones then that approve or deny the requests that come in. So, I mean, we're trying to find whether it's a third party. We have one now that's helped in a consultancy, but now we're looking to third party it with a couple of the ones we've been talking to actually do the approvals denials, right? Like you're talking about. We are uncomfortable though with the idea that if we say they are the ACC, they now have the ability to change or not change because it would have to go to a vote for anything in complete difference, but to modify. So I know we talked about a liaison committee, the current ACC before 9/1, granting the right, that specific right as an agent of the ACC specifically for the creation of new rules, the deciding of that, and then they advise whatever the new ACC then tends to be.
Sure. So the idea, you hire a third party, but you
just do the voting.
To do the voting, but ideally also, I think I follow.
Yeah, and so if you hire.
That legit to basically, my question is, I guess to summarize it, is it legit to create a liaison committee and then the current ACC before 9/1 grants the authority to the liaison committee not to vote or any of that stuff, but to simply be the ones, the creation, deciding of guidelines, those types of things?
Yeah, you could do it that way. The other way to do it would just be to hire this professional consultant, and in your agreement with them, they just agree not to change the rules. And so you just limit their authority contractually.
Okay.
So that's one easy way to do it.
You can always set up last right of, last right to review something before they get approval. I mean, something,
It specifically says the ACC has the final say,
Right.
other than going to a vote.
Right.
The board officially has no say in a final right of.
Sure.
And that's the concern.
Yeah, you can fix that contractually. I think that'd be a pretty easy solution.
Okay, thank you.
Being that it's easier to recruit a board member than it is an ACC. Okay, so I'm one of those guys. I'm gonna go and stay with the architecture committee. And board meetings are open. They're basically consensus run. So is there any issue with the influence of the non-board member into things that go on in a board meeting, except for personal violations that don't involve property use?
No.
Okay.
No problem there.
Adam, is a development period, meaning homes that are still being built within the community?
Typically, yes. It's just a period of time where the declarant, the developer of the association, has reserved to themselves some extra rights, like the right to appoint board members, the right to approve all their own construction, that kind of thing. And if you weren't appointed by the developer, then you're outside of that period.
But if the developer turns to the community for residential board,
and you're done.
still has properties that they are developing.
Meaning there's still lots that are still, a few lots that are still to be built on.
This is more of a term of art than anything else. Your declaration will control, but it sounds to me like if your developer has turned over the board control to the homeowners, you're outside of the period. Just because they still own lots and are building, that doesn't mean you fall within that.
Right.
Yes, sir.
I presume there's an appeal process. That's all this. Whereby if the homeowner disagrees with the official, they can appeal to the board, right?
Yes, sir.
Does that apply also if the board disagrees with the
Kind of. So the question is, there's this new procedure for appealing denials by the architectural committee to the board. Does that mean the board has the right to appeal, I'm doing air quotes if you can't see, appeal the ruling of the ACC committee, kind of, and I'll explain it like this. So nobody's going to appeal. No owner is going to submit their application, get it approved, and appeal that decision. Okay. So what happens is the owner applies for approval, gets denied, and goes to the board and says, I would like to appeal this decision. The board can do anything they want at that point. So if the previous ruling was a conditional approval, sure, you can have your shed, but it's got to be 10 foot by 10 foot. And the board doesn't like that, the board can say no, and you can't have your shed. So it can be kind of a double-edged sword. But if it gets appealed to the board can literally do anything. They can modify it, they can approve it, they can decline it. I think.
The homeowner says, I'm gonna take my house for the ACC says, yeah, sure.
Yeah, can they give you veto?
No, it's not a veto power, and that's where I was going. It's not a veto power of the board. The board only changes the ruling of the Architectural Control Committee if it's brought to the board by the homeowner.
Through appeal.
And only the homeowner, that's correct. Only the homeowner has standing to file an appeal.
So it may be a good idea to have a liaison on that committee, especially these rookie ACC committees that you just recruited off the street to come in here and do that. Maybe sit in on the first few meetings and help them through that, right? Do some handholding.
But remember, the ACC is still appointed by the board. So if they're making a bunch of crazy decisions, you just say, thank you for your time. And you dismiss them from serving.
Yep.
Consider the situation where a ACC committee makes a really good thing and approves something that had no business being in the neighborhood. Okay, now the board's faced with a dilemma. I believe. When you said there's no getting around it.
Yes, correct. If the ACC approves something they shouldn't have, it causes a bunch of problems. That's correct.
What was your remedy as a board member? Would you be able to go back and find
variance?
You're gonna probably have to issue a variance just to avoid the waiver issues. And then you need to either have a real serious talk with your ACC members or dismiss them from serving on that committee.
No alcohol at the ACC committee meetings, right? Like, nope, don't do that. These are important decisions, people.
2 drink tickets.
Yes, that's it.
All right.
We had one, I think it's 1242. Had a question, unmuted you online.
I have a question.
Yeah, go for it.
Does this apply to condominiums?
No. This.
Everything from here on out is.
Yeah, everything. Yeah. Well, there's a condo section, but right now this is section 209-00505 of the Texas Property Code. The prohibition of board members serving on architectural committees does not apply to condos. So you can still be on the board.
A board member can still be an architectural control committee member as well.
In a condo.
Yes, sir. In a condo.
Okay, thank you.
And one more question from Vicky.
Yep, me again. Sorry about that. So you're making some generalized statements, and the one is that ACC members are appointed, and that's not true for all HOAs. Ours are elected, and we don't report to the board. But the other point was in our CCRs. Now, I don't know if this legislature overrides that, but our board can, so a homeowner brings something to them, an appeal, and they listen to it, but there has to be a clear reason for them to override it. They can't just decide they don't like what we said unless there's a really good reason, and that's in our CCRs. And again, you're generalizing that, and I wasn't sure if this changed that.
Sure. So you are correct. There are exceptions to all the general rules, and I am generalizing because there's representatives from probably 50 different HOAs here tonight. But you are an exception to the rule. There are very few associations where Architectural Control Committee is independently elected. But that's correct. There are instances where that happens. But even if your declaration indicates that there has to be some very good reason for an appeal, that's abrogated by this new law. So I was generalizing on purpose. All right.
All right, next.
Okay, so in subdivision associations, architectural review denials now must be in writing. Hopefully you're already doing that. They must be delivered to the owner by certified mail, hand delivery, or electronic delivery. This is one reason to ensure that on your application, make people put their email address. Because the last thing you want to do is have to send, certified mail to people every time you deny an application. Hand delivery is silly. And if they put their email address on there, then now you can email the denial to them. It's faster and it's cheaper. You have to describe the basis for the denial in reasonable detail, and you have to tell them how they can get it approved. This is going to be a little complicated if they've just proposed something that could never happen. But you're required to do it, and you have to tell them that they have a right to appeal the decision with the board as long as they request it within 30 days. All the packets that we're putting together include a template letter that will help you in putting this together. It's a fill in the blank deal. We're going through and we're finding all the reasons you can say no and creating little check boxes. So what you'll do is you'll just go and you'll check all the ones that apply. Then you're informing them specifically of the reason that it was declined. And then there's going to be a little blank for you to say, if they've decided, I want to paint my front door pink, you can say, how about not pink and some other color like one of these, pre-approved colors from our palette. So we're going to try to make it pretty easy if you've elected to have us do your documents for you. All right, so now if timely requested, a hearing with the board has to be held within 30 days, and the board has to give no less than 10 days notice of the hearing. During the hearing, the board and the property owner have the opportunity to discuss, verify facts, and resolve the denial of the owner's application and talk about whatever changes might be necessary. The board or the owner can record the meeting, and the board can affirm, modify, reverse, in whole or in part, any decision of the architectural committee, as long as it's consistent with the subdivision association's declaration. And so we hear the word hearing and we kind of think it's going to be very formal. There's going to be rules that apply. There's not. It's just a meeting. It kind of sounds like the legislature was setting up this adversarial process where you'd have a lawyer there for the homeowner and some kind of advocate for the board, and they'd argue back and forth. It just doesn't have to be that way. And it can still continue to be an informal discussion where everybody just tries to resolve the differences. Yes, sir.
Our CCRs specifically say that PCC's decision is irrevocable. Does that remain or is that changed? Is this changed?
So the question is, their CCRs, the bylaws or whatever the governing document is, it indicates that the ACC's decision is irrevocable. And the question is, well, is that still the case? No, that provision of your governing documents is abrogated by the new law, and now it is not, their sole and absolute discretion. It's their sole and absolute discretion with the right to appeal it to the board and have it changed should the board decide to do that. Yes, ma'am.
So this is hypothetical. What if you arrange this meeting and you're surprised and they walk in with a lawyer? What should you do?
I mean, no, you just have them. It's just a meeting. So just because they come in with a lawyer, you're not even at a disadvantage. You continue to hold all the power, and all the lawyer can do is explain why you were wrong and you should have done exactly what their client wanted them to do. And you can listen very politely. You can ask questions, and then at the end of it, you can say, "Thank you very much. Your application is still denied." I mean, there's nothing that a lawyer can do in that meeting. Now, if they surprise you like that, you can always pick up the phone and call me and I can kind of walk you through, what to do next, but it doesn't change the procedure. You ask whatever questions you want to ask, you hear them out, you let them finish whatever they're saying, and you don't have to do anything at that hearing. You don't have to ask questions. You don't have to present evidence. You don't have to say a word besides, thank you, you'll get our ruling in writing within 30 days. So it's not that big of a deal. I wouldn't be too scared of
I
lawyers.
thought the wording said something like the HOA must present first. And then it also said you had to present, if you were going to present any evidence, you had to provide it 10 days in advance.
I think you're thinking of the violation hearings, which is very similar.
So that's not this.
That's not this, but I'll answer that question. Even though the language in the statute talks about presenting your case and producing a packet of documents and everything else.
Yeah, that's what we were like.
You can
really?
just not do it and still have the hearing and just say, well, we won't be presenting anything.
Okay.
The board already knows all the facts. We don't need to, because you're presenting it to yourselves. There's no arbiter of what's right and wrong other than the board, who is also supposed to be presenting the facts. So it's kind of a kangaroo court kind of a deal.
Thank you.
You got it. All right. Okay, so this is a simple one. Right now, if you want to have a board meeting, you need to give 3 days notice. Now, well, in 3 days, you are going to have to start giving 6 days notice. It took me a little while. I'm not that good at math. 144 hours, it's 6 days. So if you're going to do a special board meeting, it still remains 72 hours before the meeting. But the difference between a special board meeting and a regular board meeting is kind of nuanced. If you have a board meeting on the third Thursday of every month, now you have to give 6 days notice for the regular board meeting. If for some reason you need to have an ad hoc meeting that is not a regularly scheduled meeting, you've only got to give 3 days notice. So I'm not sure what the thinking was there, but that's how it works. And they also added that all amendments of the annual budget, instead of, it used to be if you were going to increase the annual budget by more than 10%, it had to be approved at an open board meeting. Now it's any amendment to the annual budget has to be approved at an open board meeting. So just keep that in mind.
Do workshops?
No, as long as you're not voting, boards can get together and do whatever they want to do.
Okay, but in workshops, decisions are formally made and voted on at a regular meeting.
Well, the law can't keep the 3 or 5 or 7 or 9 board members from just getting together and talking. You're just never going to get in trouble for that. If you regularly hold workshops and make all the decisions and then go to the board meeting and have a 5-minute board meeting where you vote on the 10 things you've already discussed, don't do that. But as long as you're not voting and making decisions at the workshops, you're not violating the law. It's only when there's a quorum of board members that are there to do the business of the board and vote on that and make those decisions that you run afoul of the law. Does that make sense?
No, it makes a lot of sense. And it's,
We're in trouble.
vote on anything.
Yeah.
If you're not planning on voting on anything and you don't vote on anything, you're probably not having a board meeting. If that's the way you normally do business, though, you should consider, going ahead and having open board meetings. But if once a year you get together and you sit down with all your spreadsheets and you try to plan out the budget and you just, sit in someone's living room to talk about what we're gonna, let's set the agenda for the next meeting or a strategy session or something like that. That's not a board meeting, and you'll be fine. And as long as you don't make decisions that are binding on the community, you're in good shape.
Let me help you with this, is we may be in trouble here. So we may have a contractor come out and fix some bricks or do some electrical work, $5,000 at whack, something like that. And we'll get together online and we'll say, or we'll get a reserve study or even an audit. And we'll pick through the proposals and agree on who to choose. That's not been, so far in 6 months we've been doing this, a public meeting. Are we violating the meeting structure?
No, there's a list of 15 items that you cannot make decisions about. And I don't have them memorized. I think we can talk about them later, but there's 15 items that you simply cannot make decisions on outside of an open board meeting. Those, as long as the decision you're making does not fall into that, category of 15 items, you can decide by email and vote that way. And then at the next open board meeting, discuss the decision you made, get it into the minutes in an open board meeting. As long as it's not one of those 15 items.
If you're doing your due diligence, you have to go meet with a contractor, agree on the scope, kind of work through the details, and then go ahead and formally allow, the board to weigh in and vote on it. It's okay. All right.
Yeah.
I mean, the idea is that, the whole idea here is to be as transparent as possible. Now with Zoom, if you guys have a workshop, you want to pop open a laptop and invite people into it, call it a meeting, but you mute everybody. You don't have to answer questions. You can just kind of let them hear. That's viable too, right? I mean, nobody shows up anyway, so it's usually not a big deal.
Exactly.
If you're worried about it.
One caveat to what I just said is if you're making decisions via email, make sure it's not one of those decisions that has to be made in an open board meeting. And it probably should be unanimous unless your specific governing documents indicate that you can take an action outside of a board meeting with less than unanimous consent. And your documents probably don't include that. Now, this is not a widely publicized opinion. There's never been a case that says this. But if you look at Section 22 of the Texas Business Organizations Code, which governs nonprofit associations, and then you look at your own bylaws and your own declaration, it seems to suggest, and in Section 209 of the Property Code, it seems to suggest that you can vote outside of a meeting and it be less than unanimous. But when you go back to Section 22 of the Business Organizations Code, it only allows unanimous consent outside of a regular meeting, unless it specifically is specified in your governing documents. So it's kind of a circular deal, but just be cautious about that and don't go voting on email for everything you do. Yes, sir.
Like, simple example, like approving of the dues for the following year. That needs to be an open board meeting.
Probably, because approving the dues for the next year is a function of approving the budget.
Right.
You can't know what the dues are going to be without knowing what the budget is. And I would imagine that happens simultaneously.
But there's probably a 3-hour conversation about what goes into the budget, what we want to do, what we're going to increase, what services are increasing, what we're cutting, all of that stuff. And that stuff happens in a workshop, right? You're having conversations about how you get there, and then you can vote on the budget at that meeting. Dennis, you had a question on joining us online?
Yeah, on the last one, as far as the amendment in our bylaws, we can raise the dues up to 10% every year without getting a vote. Does that mean now, if we want to raise the dues even by 1%, we have to get a vote from our homeowners?
No, it just means you have to approve that increase at an open board meeting, just the way you've done in the past.
In any event, as a group, approve the budget, approve pass the budget, right? Which also leads to whatever your billing looks like, at an assessment level.
Okay, thanks.
Okay. I didn't approve of $150,000 with fence. And there were a number of things that I disapproved of. And we voted by mail. And it was real frustrating because I thought something else came up. Somebody disagreed. So it's what you're saying, if it isn't unanimous, then we need to go to an open board meeting.
Okay, so the question is, if we have a vote by email and it's not unanimous, do we have to do it in an open board meeting? And the answer, unfortunately, is maybe. It's going to be dependent upon your specific governing document, which I'm happy to take a look at sometime.
Okay, what if somebody doesn't respond? Like we have a board member who, let's just say, doesn't always respond.
Then it's not unanimous. Okay. So we'll have to look at
But what percentage of documents say something to that effect?
It depends. About 25% say less than unanimous consent.
It's very few.
Yeah. Also, nobody's ever made this argument challenging it before. And a lot of people make decisions via email. I'm just trying to be complete and not lead you astray with some bad advice. But It seems to be, when I read all of the law that applies to HOAs, it's got to be unanimous.
I say whenever possible at a meeting, ratify that vote, right? Like
Ratify everything.
make sure you ratify it,
Yeah,
right?
whatever you do, if you vote by email, just ratify it at the next open board meeting, and 99% of the time, you're gonna be okay.
But you can do it almost like, just say, hey, previously we discussed this, the vote was this, we want to ratify it, all agree. Yes, all opposed, say no, and
That's
that's
it.
good enough.
That's it.
Okay,
Just make sure it goes into the minutes.
that's what I, okay.
Online, just unmuted somebody. I don't know who it is though. Question? Questions? I unmuted you.
Yes,
Yes.
I have a question.
Yeah.
So what are the 15 items we cannot
I'll
discuss?
email those to you in the recap. It's a laundry list.
Yeah,
So can you provide that to Town Square and so that we can see it as board members?
I'll find it before we're done today.
Yeah, and if you really are anxious, you can just Google Texas Property Code, section 209.0051.
Okay, well, I'm 75 years old and I was an architect for 30 years. And I've been on hundreds of boards and hundreds of architectural control committees. And all of this is new.
Yeah.
Yes, sir. All right.
So, thank you.
You got it. Okay, here's another one that does kind of change the way we do business. And again, this is only for subdivision associations, but it requires a subdivision association that wants to spend on one single item, $50,000 or more, to have a bid process or bidding procedure prepared. It doesn't tell you that you've got to go get 3 bids. It doesn't tell you that they have to be qualified. It doesn't even tell you that you're supposed to accept the lowest bid. You just have to have a procedure, and it's got to be filed in the deed records. And this is part of the package that we're provided. It's a very simple policy, but it limits what $50,000 means pretty significantly, so that you don't have to go and get bids for things that you regularly contract for. But this does change things a little bit, and it does require you to have this bidding procedure. There is a change to the provisions of the property code that allow you to report delinquent accounts to a credit reporting agency. It restricts you from reporting somebody if they have disputed the amount that is due. And it also requires that you give 30 business days notice to somebody that they are delinquent before you report them to a credit bureau, which is just kind of hard to calculate in your head. But besides that, it's not a big deal. If you are reporting delinquent folks to credit bureaus, your management company's handling it for you, and they're gonna do all this. So there's not really much for you to do with respect to this, other than know that the legislature is paying attention to this issue, and reporting folks to credit bureaus is a hot topic.
Dr. Kabiri, do you have a question?
Yes, I have a question. I'm sorry, I joined, I had trouble like connecting, so you may have discussed it. I'm just like asking if you haven't.
Yeah,
so with the new law about fencing, putting like security fences, for the neighborhood. So my question is, like if you haven't given any details, if you can give us some details. And second part of the question is, what if somebody requests for it? Is it the board that's gonna make the request, make the denial, or the ACC is gonna do that? Or can they get because it's the law now and we might not be able to, can we just like apply the bylaws to the decision, or can they get a lawyer and sue the board or the management company back because of the decision? Just a little bit clarity about that.
So as far as the security measures, so a homeowner can reasonably install a perimeter fence. And so the conversation we had and what legal counsel will draft for you is a set of guidelines around what is permissible. So if we can't stop someone from doing it, we can reasonably restrict what type of material height, all of the details around what can go into that to allow it to happen. And so that's essentially it. So you can't stop somebody from doing it, but you can provide clarifying guidelines around what they can do if they want to do it. They still have to submit that through the Architectural Control Committee or ACC, ARC, whatever you call it. And so that's that part. As far as the was the second part of the question was?
Well, I think the question was who makes the decision? It's the ACC that makes the decision.
Yeah.
And you ask, well, what if the homeowner doesn't like it? Can they sue the board members and the ACC? And the answer to that question is yes. We defend all kinds of lawsuits, both good ones and those that are frivolous. So homeowners can sue you for almost anything. It's just that rare that they ultimately prevail.
Real quick, that list of 15, thank you, Dr. Kabir.
I have a question about lawsuits.
Yes.
And if they lose, can we charge for the legal fees back to them?
It depends what the lawsuit's about. So if they're suing you for breach of fiduciary duty and
A tree fell on the car on the city street. It was in their property.
so in that case, you're just defending against a liability claim. You might not be able to collect. Certain declarations indicate that if there's a dispute between the HOA and the owner, the prevailing party will recover their attorney's fees. You see that in maybe a third or half of all documents, but that'll be in the declaration if it's applicable. All right.
You want me to read that list off to you all real quick of the things that
better you than me.
Yeah, we'll email it. I'll send it to you guys. That's fine.
All right. So that's the credit reporting deal. Okay. Just to be complete, we've included this. It's a minor change. It requires that if you're going to apply somebody's payment that they make to you towards attorney's fees, the attorney's fees have to be reasonable. We've always taken the position that they better be reasonable, but now the law requires it.
Define reasonable.
Well, the whole legal system rests on the word reasonable.
Let me rephrase it, Adam. If it's a standard attorney fee, that's the norm within the industry. That qualifies for reasonable?
Absolutely. Yeah, absolutely. And if you're charging everybody, the same flat fee for the same, letter, and everybody's having to pay for it, most likely you're going to be in good shape. All right. So previously you were required to give owners a 30-day notice before sending them to either a lawyer or charging them additional collection costs over and above, the regular assessments. Now you have to give 45 days notice. But again, this is something that your management company is well aware of and will certainly be abiding by on your behalf. Now, we talked a little bit about this, but if you are going to send somebody a violation letter, fine them, or otherwise enforce your restrictive covenants against them, you now have to give them the right to a hearing. Now, you always had to do that, but you used to be able to delegate that hearing to a special committee. You no longer can do that. It has to be in front of the board. The board must designate a director or other representative to present the association's case against the owner. Again, like I said, it sounds like it's this formal procedure, but the case against the owner most likely is a photograph of the violation and a date and a time. So that's the whole case. So I wouldn't consider that to be that much of a huge responsibility if you're that board member. The board also has to provide the owner a packet containing all of the evidence that will be presented at the hearing. Well, if you don't provide the packet, you just don't present any evidence, but it's not a court of law. So if you forgot to bring the picture with you and you forgot to give them the packet and everybody on the board drove by that house earlier and saw the violation, there's no reason to have any evidence at the hearing. So this rule really doesn't do anything. But you should try to abide by it as much as you can. We should provide this packet of information to the owner. But the real answer is it's already been provided. Anything that you're going to be showing at the hearing to prove that they violated the restrictive covenants is what you've already sent them. The violation notices, from the last 9 months, plus the latest picture. So not a big deal.
For years, board members have been asking for people to show up to board meetings. Now you got like a line of people that will show up to your board meetings wanting to meet you. So,
exactly.
Do you think, so can a homeowner just walk into a meeting and ask to be heard, or does there have to be a specific notice period in all these?
Oh, that's a good question. Yeah. So if an owner wants to have a hearing, they've got to request it in writing. And so, you're going to get notice of it. You're going to be able to set this hearing whenever you want to set the hearing. And communicate with them in writing. They can't just call you on the phone and say, I want to have a hearing.
Mm-hmm.
So the legislature also made some minor changes with respect to 209-016 of the property code. It rescinded provisions regarding redaction of sensitive information in a lease agreement provided to your association. Now, this does not expand your rights or owner's obligations. It simply says, if you have in your declaration already the right to request information from owners about tenants, like getting their lease, they no longer are allowed to redact a bunch of information. The point is that you have all of the information that the owner has about the tenant. It also clarifies that this new change does not affect the enforcement of any leasing restrictions, and it authorizes a subdivision association to request contact information, mailing address, phone number, email address of every person that will reside in a piece of property under a lease. And it allows you to request the commencement date and term of a lease. But again, you have to be authorized to get this information in your declaration anyway. So this, like I said, it doesn't expand what your powers are. It simply reduce the limitation on what you can get. Okay, and so now we're into some of the more minor changes. This new provision of Section 209 allows property owners to sue subdivision associations for basically any violation of Section 209 of the Property Code in JP court. It sounds like that's going to create a bunch more lawsuits, but I can just promise you, if somebody was mad enough at you to go file a JP lawsuit, they were already doing it. And this just allows them to do it in a way that's a little bit simpler. But again, they have to have damages. So if they just find some ticky-tacky violation of 209 where you forgot to send a notice, or it said 10 days and you miscounted and you sent a 9-day notice and they go see you in JP court, the JP court can't order you to do anything other than pay money. And so it doesn't create some new liability or increased liability for HOAs. It just creates a new vehicle to resolve the disputes. But I don't imagine that this will be too prevalent. So again, another very minor change. If you were going to amend your declaration to try to limit commercial, industrial, multifamily, or the condominium use of your property, and those uses were already permitted, you can't do that anymore. So if you're in a mixed use development, for example, and you've got residential over here and some commercial over here, the residential community can't get together and vote out the commercial use. And that's what this protects. So unless you're in a mixed use community, this probably doesn't apply to you. Now, these are the provisions that only affect condos, and there's not a lot, so we're almost done. Okay, so previously there was a requirement for subdivision associations that if you wanted to charge somebody for producing copies of your records, you had to have a policy on file. This adopts that exact same ruling for condominium associations. And if you have 8 or more units, you are required to adopt a document retention policy as well. But a document retention policy is simply a policy. It's about 1 page long. We filed the deed records, and it says how long you're going to keep all of your various documents. Real simple. And we've got a package for condos that's pretty simple. Get you these 2 resolutions. we get them on file, and then you're in compliance with the law.
How'd the condos get off so easy?
I don't know. I think the legislature just got tired of messing with this towards the end. So what do you need to do now? Here's the to-do list for condo associations: adopt a records production and copy charge policy, and adopt a document retention policy. And we can produce those for you. It's pretty easy. For subdivision associations, you've got a little bit more to do. You need to adopt a contract procurement policy, adopt permitted regulations for swimming pool enclosures, adopt permitted regulations for security measures, adopt permitted regulations for displayed religious items, adopt procedures and guidelines for architectural review, and adopt procedures and guidelines for enforcement and architectural review hearings. We've got the condo package is $350. For subdivision associations, we are charging everybody $1,500 unless you are managed by Goodwin, and it's only $700. They negotiated us down because we're doing so many of them, and we're happy to offer that discount to all of the Goodwin subdivision associations. We've got a packet order form that we've already sent out. You should have it. If you haven't seen this yet, your manager's got it. Ask them for it.
Anybody in the room or online, like, haven't started this process or has no understanding of where we are?
But I know we've had to just.
Yeah.
We're in good shape, but that's the form. And I can just tell you, if you haven't filled it out yet, fill it out quickly, but we're not going to meet the September 1st deadline. Yes, sir.
Okay, so that form, we need to get it formally filled out and back.
Maybe. With a lot of your managers, they were ordering a lot of these all at once. And I let them just email me the information without filling out the form. So it could be they already ordered it, or you didn't fill out the form, but it was ordered anyway.
We responded back that, they wanted to have it done.
Yeah, I'm not holding you to some technical thing. Well, I don't have a form, so I'm not. If you've asked us to do this work and we're already on top of it, and you've provided the information, rest assured we're taking care of it. This is just for people that haven't heard of this process yet.
One more question. Trish, do you have a question?
Yeah, is that form the same thing that Goodwin sent out to us, that
Yes.
survey that we had to fill out?
That's exactly right.
Yes,
Yeah.
ma'am. That's it.
Thank
Just made
you.
it electronic. Thanks.
All right.
That's 100,000 documents are going to be filed in every county exactly at 5 o'clock. Does it matter if it gets recorded or not?
Well, it has to be recorded. But at midnight on September 1st, nobody's turning into a pumpkin. The only real requirement is that the management certificate is on file as of September 1st. These other issues could come up, but not necessarily. And so it's important that we act quickly, that we try to meet the deadline that's been set by the legislature. But if your next board meeting isn't until September 15th and you can't adopt them before then, or everybody's out of town, or we don't get it filed until October 1st, most likely there won't be any problems. Does that help? All right, anything else? I've been talking for a long time. All right.
I think
Thank you very much.
Thank you, Adam. I think we'll try to keep this our little secret and not let everybody know about the religious displays, and we'll be all right. All right. So we'll try to keep that to ourselves. I wouldn't put that in the next newsletter. Hopefully people won't catch on.
All right.
Adam, thank you, bud. Appreciate it.
Very much.
Thank you all.
Thank you all.
Well, Dr. Kabir, you had a question?
I had one quick question if you still have time.
Yeah. Give me 1 second. Oh. Sorry, I muted you by accident.
That's okay.
Thank you all for participating. Appreciate it.
Of course. So the
Give me 1
quick
second.
question I had.
He's
Can you
talking to
hear me?
somebody, but I'll try to, he's talking to somebody, but I'll try to answer for you.
Okay, so as far as the security measures, what I was wondering, like as far as the details and what it has to look like and all. So does it go back to bylaws? So they have to follow the bylaws. And as far as the place that they can put the security measures, so can they put it like everywhere, like go around the backyard or anywhere, or it has a specific like limit for where and how they can like place it?
I'll send it to you.
Yeah, the answer is pretty much yes. They can install it basically wherever they want within reason. The idea is that we're still going to require that these requests get submitted to the ACC for review, and that, you know, that might yield a discussion if there's something that is deemed to be unreasonable. But the idea is that, yeah, I mean, somebody wants to install, you know, a front yard fence, they can. So the whole idea behind the paperwork that the attorneys are drafting for us is that they are creating guidelines for what can be done if a homeowner requests that they do so. If you'd like, I can email you some sample language around like what Adam's drafted with those security measures, so you can get a feel for what that is. It doesn't replace the documents, right? It doesn't, in some cases, if your documents are in conflict with the statute wins. And so what these guidelines do is that it gives you the ability to create some clarifying language. So even if your documents don't win against the statute and they're now kind of irrelevant when it comes to a certain section of this that's now been allowable by statute, these rules, which the board can pass, creates some clarifying guidelines around what is permissible. So if you'd like, I can email you. I'll send out a note to everybody who participated online and in person today. I'll send you guys I'll send you a copy of it. Just respond back to the recap email that I send out.
Sure.
And I'll send you some samples of what that looks like, so you can wrap your head around how it all works.
Okay, that sounds good. So just like just one like clarifying question, like for example, if somebody like tomorrow, we see a neighbor that start like putting a fence around the front yard, that the front yard comes all around, all in front of the house and all around, and they follow bylaws. Now I'm just like making up an example, and they follow bylaws for the material that they use and everything. So can we stop that neighbor, or we have to
technically yes, because it's still an addition to their property that wasn't approved by the ACC. If you don't have anything recorded, if you will, with these guidelines in place, then it becomes hard to defend the position as to why they can't continue the same wood fence on the backyard and the front yard. So the idea is to get these in place so that there is that language in place. But with any improvement to a community, what the documents say is that it still needs to go through a committee's, through the association's approval. And so we can still review those and we can still reject them. But if you reject it and you don't have those guidelines in place, it becomes really hard to defend your position as to why. That makes sense?
Yeah, that's correct. So the thing is, now if you reject them, so technically it's a security fence, like in their language, and they're following the law, like in their like in their opinion. So can we get sued for that, or how does that work? That's what I meant.
Adam mentioned, I mean, there's never nobody, you can never stop anybody from suing the association. It's a function of, what gets agreed to. I mean, ultimately, as long as you can get these documents filed and you create those guidelines, now you've got something in place that says, hey, you can do this, but here's what's reasonable. Here's what the association requests if you're going to do so. So wrought iron front yard perimeter fence. It's contiguous across the entire property boundaries. Something of a certain height requirement, and that way you can ensure consistency from the street view, right? So that aesthetically all the homes look the same, or within reason look the same. You don't have somebody putting in a neon pink fence. You can say it's wrought iron painted black, right? Or something to that effect. And so as long as we get those in place, that helps. And so that's where these documents that the attorneys are drafting are really important, because you want to make sure that there's no gap in time from the time somebody submits an application, then you don't have anything to stand on, because you're denying it based on what? well, you're denying it based on nothing that's really recorded, right? Nothing that has been passed by the board as a rule. And so it becomes a little harder to defend your position, but ultimately it's still susceptible to the committee to review and approve. And so from that standpoint, it buys you a little time, but ultimately you might not win on a, you know, if it gets appealed, right? If it gets appealed to, you know, somebody takes it to court. But by then you should have some reasonable guidelines in place. And I'll send you those documents. I'll send you kind of forward, and Adam put together like 4 examples of different types of materials that you can use. In the documents I send you, it'll be highlighted in yellow. You can kind of take that language and play with it and add your own special requirements to it. And as long as it's reasonable, I think we're good to go.
Okay, thank you, sir. I appreciate it.
Thanks, you got it.
All it takes is a board. A couple of crazy.
Hey, Anthony, do you have a question?
I just have a question. Will this recording be available on YouTube?
Sure
like
will.
it was earlier?
Yeah, I'll put it on there tonight or tomorrow morning, depending on how long it takes to download.
You all have been excellent. Thank you very much.
Thank
I
you.
appreciate all your help.
You got it, absolutely. Thank you all. Have a good night. Hey, Maggie.
Yes.
Hey, Maggie, I'm so sorry I missed your chat. Is there anything I can help answer?
Yeah, I just had a board member that was asked, that wasn't able to make it and was asking, he lives in a, what is considered a townhome HOA. And I explained it to him earlier that he'd fall under the condo law, but he was stating that he didn't believe they were condos because the original owners and himself used the VA loan to purchase. And through the VA, they had to finance as, I guess it was a different process because it was, because it wasn't a condo.
Right.
So he said that he didn't believe that they'd fall under the condo laws as a townhome.
Yeah, we'd have to look at the documents. Just because it's a townhome doesn't mean that it would be necessarily a condo. Condos and HOAs come in all shapes and forms. Sometimes you look at what looks like single family detached homes and they could be condos. It's really just all in how they were incorporated. So we'd have to look through the documents to determine, there's usually some reference to what the intent of that association is.
Right.
And sometimes it's any number of different places. A resale certificate is probably a good starting point, I would say. But yeah, if you want, you can pass on his contact information. I can look up the recorded documents and try to figure it out for him. Okay. Thanks, Maggie. Thank you all.